And now we have the third and last presentation for this corporate law session, and the speaker is Professor Claudia Sandei from the University of Padova. Please,
thank you.
Professor.
Thank you very much for the stage, and thank you to Emanuela Arezzo for the kind invitation. And the topic I would like to speak about today is about the impact of blockchain on shareholders' rights and corporate governance more in general. We have heard by Nicola De Luca that shareholders can rely on blockchain in order to have their shares registered. So it can, in a way, help. He said not too much, but somehow it can help to have a smoother market, and so to have an easy way to transfer shares, and this can, in a way, can represent an advantage also for shareholders' rights. We will say something more on this point later on. As you know, the empowerment of shareholders is one of the most controversial topics ever, and since the very first Shareholders' Rights Directive in 2017, the European Commission has been committed in enhancing shareholders' engagement, especially in listed companies, in the belief that this can serve as a means of good governance, thus resulting in higher profitability, but in higher market integrity as well. So we know that there is the importance of engagement of shareholders is much more stressed in Europe than in the US, where it is, in a way, more difficult to reach. And so today we are trying to understand if the blockchain can help to reach this goal, so to have much more empowerment of this kind of shareholders. So the starting point of my conference is that in 2014, the European Commission appointed what is called the Informal Company Law Expert Group, ICLEG, and to assist it with expert advice on issues of company law in general. And in the 2020 Capital Markets Union Action Plan, it is stated that shareholders' engagement must be further facilitating by making voting easier for all investors and corporate actions more efficient in a cross-border context. So in this report, the group states that to have this kind of enhanced engagement, we should maybe consider the idea to use technology. This is not something new. We know that we have already experimented what is called e-voting in the first Shareholders Directive. So it was dated 2007. And so it's not something new, but now it seems that the experts are considering something more. I mean, the advent of new technologies. It's no more just the internet, and in the document they mention the pilot regime. And so it seems that they are thinking of the blockchain as the new technology that could help to solve the puzzle of shareholders' engagement. So it's not really expressed, it's something implicit we can understand by reading the whole report. So the outline of my presentation is the following. So we will start from setting the scene. So where are we now? So where we stand now, and then we will start considering whether the blockchain can do something more than just helping registering the shares. And so if we can dream together with the expert group of a different corporate structure, meaning that we can empower more shareholders through the blockchain. So the pilot regime, as Nicola De Luca said, is about the equity tokens, meaning that we can use the blockchain in order to register. We have an equity certificate on the blockchain, and it is quite similar. He said even too much similar to what we were used to, and they are stored on a distributed ledger than a share register. And this is something we have enacted in Europe, but before Europe, other nations, either in Europe and outside Europe, did the same. So what happened with the pilot regimes, what is now in force because of the law is that we can use DLT to register the equity tokens, so we can transfer the tokens and they represent some shares. And they have some pros and some cons, and some of them have been well described by Nicola, saying that they can have some improved traceability or security or whatever, but we share the same view on this point, that it is, a very complicated technology in order to achieve what we already, in a different way we were used to achieve. So it might be that sometimes it is less expensive, sometimes it might be faster, sometimes, but they are not so relevant Advent Pro. So we must say that if all the reform is about this, is not so relevant for our legislation and our economy as well. And so the elephant in the room, meaning that there is something much more important we are not dealing with, or we have not dealt with yet. And I think it's the possibility to code, so to use smart contracts not only for what Nicola said, so for transfer, but for transferring the shareholder rights. So to have some voice, not exit, but voice in the smart contract. And so what's the situation from the legislative point of view on this topic? As I said, there are some references to this, but they are not so explicit. In the Article 7 of pilot regime, it is written that operators of DLT has some duties as regards security and the effectiveness of the system, and they shall ensure continuity and continued transparency, blah, 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 including the reliability of smart contracts. So what are those smart contracts about? It seems to be smart contracts for the availability of the network, so meaning the mechanism of consensus or those kind of stuff. It's not something that automates the transfer of shares nor the shareholders' rights. But then in Article 14, there is a reference exactly to shareholders' rights and DLT. In the last part of this quotation, you see that by March 2026, the Markets Authority shall present a report to the Commission on, among other things, direct exercise of investor rights by means of smart contracts. So meaning that it seems that the pilot gives some space to the elephant, saying, we know that there is this elephant in the room, and by 2026, we will try to address this topic. Now it's too early, one step after the other, so something later. And here is a chart. I tried to put some order in order to see what is possible to do with the blockchain right now and what will be possible in the future. And then the final question will be, is it desirable? I mean, the blockchain can allow us to do a lot of things, but are they really useful and desirable? So let's start from, you can see on the right, there are some symbols. The green light means that you can do it. You can do it nowadays. And then there is a question mark. We are not sure. Probably we cannot do that. And then the the last is about the autonomous ownership, meaning that there is an algorithm running the company, so without any board, and this is in red flag because it's not possible according to our current legislation. So starting from level first is e-voting with blockchain, so shareholders can vote through the blockchain. This is something we already do. In a company like Iberdrola in Spain, they do that, meaning that if you want to vote through the portal, meaning you vote at a distance, they have put in place a blockchain-based system to register the voting. So as we can register shares, we can register votes. But this doesn't change too much the substance of what happens. You are a shareholder, you have to legitimate yourself through the record dates and other stuff. So everything is completely the same as in traditional AGM, but what changed is the technology which is used to register your vote, which can help to make proxy voting easier or to have much more security or even transparency, because in the website of those companies, they say once you have voted, you can check how your vote has been registered, and so you can verify that there is no mistakes. But this is, level first. It's just something we can do, and it's not something very future-proof or so oriented. And then there is level 2 is what we have already discussed, so about digital ownership. So we can even register the shares, and we can transfer our share through the blockchain. So going upper in the pyramid, there is level 3, smart ownership. This means that you can code in your blockchain also some shareholders' rights. For example, if you have limits to the transferability of shares, it could be possible to code them, meaning that everything will be automatically, and you will not be able to overcome the limit, or you will be entitled to receive your dividends in an automatic way. You don't need to ask them to be paid, because everything is driven by the smart contract, by the algorithm. And I think that this should not be prevented by the law, which is now in force. It should be something feasible, I think. And then there is level 4 and level 5 are much more related to what shareholders can do than how they can do that. So a level 4 is about distributed ownership. So to use blockchain to give back to shareholders the property of the company, meaning that they can have much more voice power. They can interfere more on the governance of the company. And in some countries, I brought the example of Utah, they passed this DAO Act, and in this act, it is written that you can establish a company, and that company is limited, so shareholders do not carry on some liability, but, well, some liability can arise, but this is not the point. The point is that you can entitle the shareholders to have many rights in order to decide the activities that the company should run. You will have an administrator, but the administrator is not someone who has to decide, is the person who has to execute what the shareholders has contributed to decide working together. So there is a distributed ownership, meaning that shareholders can concur, they can vote on administrative issues. And then there is the administrator who has the role to bring this to a different level. And I think that this is a question mark because we know that particularly in limited by shares company, so società per azioni, we have some limits according to what shareholders can be entitled to do. In limited companies, we have much more flexibility, and it might be that we could reach this kind of distributed ownership. So the level 4 is about a decentralized decision making, and this can have much more accountability and transparency. And the question is, what about the European Union? Can we do that? Are those partnerships? And so can we accept this kind of organization, and are governance tokens addressed by the MiCA? In the MiCA, which is the Market Infrastructure Crypto Assets Regulation, there are no provision about hybrid tokens, and it is written in a proposal from the authority, the markets authority, that those kind of governance tokens should be probably treated as securities, but the legal status of those governance tokens is not so clear. So we must say that in Europe currently, this distributed ownership is limited by the current regulation. So it's not something we have to say, no, it's not admitted, but we must be careful in order to address this kind of topic. And here is about the MiCA, but I can skip it. And then the final level is about the DAO, so the autonomous corporations. This means that it's no more on the shareholders to decide. It's no more a distributed governance, but there is an algorithm, and it is, it has its own rules, and it can decide in an automatic way. Of course, DAOs can work properly only for companies which has very precise activity. So, for example, investment funds or other stuff like that. They are not able algorithms to process a big amount of data, and so to run different activities. But the question is, if we want to have algorithmic-driven companies, you know that in some US states, they have admitted DAOs, meaning that you don't have even any board of directors. And in Italy, and more generally in Europe, this would not be possible according to the current legislation. But the question that the European Central Bank is now trying to explore is that we should allow this kind of organizations. And so to conclude, I think that we paved the way through the pilot regime to a different business structure, meaning that we can rely on the blockchain. But the problem is that we want to move from digital ownership, so digital shares, to smart shares, or something which allows you to automate, in a way, the way you run the company, and to distribute the power of deciding in the company. So I think there are three different levels of technology-based or technology-driven companies. There is a gap, and now we are technology-based, but eventually we can decide to move to those. And the question is, do we need all this? I mean, is it desirable? Is it really something that can bring to add value, or is just because it's a buzzword and everyone wants to have this kind of technology fancy companies, and as Nicola said, for the register of the DLT. And I'm quite skeptical. I mean, I did this presentation to say we can do a lot. I'm not sure that this is something really we really need. Thank you.